I'm Laura Hansen. Tonight we're in New York City, where a quiet vote with loud consequences just reshaped the city's legal engine. The City Council has confirmed Stephen Banks as the new head of the Law Department. If you don't follow the personnel charts at City Hall, that might sound procedural. It isn't. This is a pivot point. The Law Department is the city's shield and its sword. It defends against lawsuits, prosecutes complex claims, drafts the legal spine of every policy, and tells agencies what they can and cannot do. In a city that spends billions on litigation and settles thousands of claims a year, the person at the top can tilt outcomes. Faster settlements or harder fights. Policing standards and protest rules. Homelessness policy and right to shelter. Immigration, labor, land use, public health. It all runs through that office. Stephen Banks is not a typical pick. He's built a career on the other side of the table. Former head of the Legal Aid Society, then the city's social services chief. He's known for fighting the city, then reshaping it from the inside. When you put someone like that atop the law department, you're sending a message. Mayor Zohran Mamdani sent that message by naming him. The council underlined it tonight by confirming him. But nothing this big moves through City Hall without friction. Opposition formed early, and it didn't come from outside. It came from inside the council itself. The lines were drawn around more than one man and one job. They were drawn around the future of how the city interprets the law and how it treats the people who fall through the cracks. Tenants in housing court, families in shelter hotels, migrants in temporary intake centers, small business owners hit with contradictory rules, drivers hurt by potholes waiting months for claims, and the city workers inside a strained legal department, buried by caseloads, making judgment calls that cost taxpayers real money. Let's set the stage. The Corporation Council, what most people call the head of the law department, runs the largest municipal law firm in the country. Thousands of lawyers, hundreds of staff. Every agency's counsel reports up into this pyramid. When the NYPD faces a civil rights suit, it's the law department at the table. When a wrongful conviction claim lands in court, it's the law department weighing evidence and settlement risk. When a new executive order declares an emergency around asylum seekers, it's the law department that drafts the language, defends it in court, and sets limits for how far agencies can go. Under strain, this machine slows. When it slows, costs rise. And for the last few years, the machine has been grinding. Lawyer attrition up, salaries lagging the private sector, backlogs in tort claims, more outside counsel, more spending, and a pandemic hangover of emergency orders and lawsuits that never seem to end. That's the shop Stephen Banks just inherited. Banks is not a blank slate. He made his name at legal aid, pushing the envelope on right to shelter, education services for vulnerable kids, and access to counsel for tenants facing eviction. Then he crossed the aisle, into government. As the city's social services commissioner, he expanded rental assistance, worked with the courts on right to counsel in housing, and clashed with colleagues over encampment sweeps and shelter conditions. Supporters call him steady under pressure. Critics say he confuses advocacy with governance and pushes the city into costly consent decrees that tie administrators' hands. That's the fight you didn't see on the evening news chyrons. It spilled into committee, where Councilmember David Carr and a block of skeptics tried to slow the train. They framed the question like this: should the city's top lawyer be a former litigant who made a career suing the city, who moved into social services, and who now would call the shots on legal exposure across every agency? Inside the chamber, the interrogation was thorough. Cases were dissected, budgets were combed. People who lived the outcomes of these fights were symbolically in the room. Families in shelter who got placements faster under rental assistance expansions, and people left in limbo when placements stalled. Tenants who kept their homes because they knew their rights, and landlords who said the system moved too slowly to be fair. Victims of police misconduct seeking justice, and officers claiming the city settles too easily and tarnishes them by spreadsheet. And then there are the taxpayers who foot all of it. Banks did not walk in promising revolution. He walked in promising competence. Fewer surprises, quicker decisions, settlements when it's cheaper, trials when it's right. He talked about recruiting and retention. He talked about risk management at the agency level, training and early warnings so that the law department isn't forever playing cleanup in court. But listen closely, and you could hear a deeper shift. Under this mayor and this council, the law department may pivot from reactive defense to proactive offense. That means more affirmative litigation, cases where the city sues on behalf of residents. Think climate accountability, housing discrimination and deed fraud, wage theft, consumer scams aimed at immigrants and seniors. That's a different posture. It's not just saying no in depositions. It's saying yes to courtrooms as a tool for policy. Where does the friction start? Staffing. The law department has been losing experienced trial lawyers to firms that pay double. Caseloads stretch, deadlines slip. When you settle too fast, you invite more claims. When you fight too long, you spend more than the settlement would have cost. In an office this large, culture is policy. If Stephen Banks can hire, stabilize, and keep talent, he'll build the runway he needs. If not, all the promises run into the same wall. That's why insiders watched for what he said about work conditions, hybrid schedules, pay bans, training, career ladders. He nodded to all of it. He also tied staffing to strategy. Fewer outside counsel contracts, more in-house expertise, and more data to identify repeat patterns that generate lawsuits in the first place. Slip-and-fall hotspots. Police units with outsized claim histories, agencies that bottleneck approvals and generate avoidable litigation. The second friction point is homelessness policy. Banks's name is practically synonymous with right-to-shelter litigation. That makes him uniquely qualified and uniquely controversial as he steps into a job that now defends the city's response to the asylum seeker influx. The emergency orders, the intake center standards, the time limits for stays, all of that is tied up in court. With Banks at the helm, the city could move toward negotiated standards rather than endless motion practice. That could bring clarity faster. It could also harden obligations and lock in costs. If you believe the city's obligations were eroding, this is a course correction. If you believe the city needs flexibility to manage capacity, this looks like a risk. Third, policing and public safety. The law department handles civil suits tied to police conduct, protest activity, surveillance, and jail conditions. It also interfaces with federal monitors overseeing reforms. The fights here are not academic. They decide how quickly a city admits fault, how it disciplines misconduct, and how it defends officers who acted within policy but in gray zones that juries don't like. Expect more pre-trial triage, separating strong plaintiff cases that should settle early from weak claims that waste public money. Expect more use of data from monitors to guide those calls. Expect resistance from both ends, advocates who want bigger payouts and policy shifts, and unions who see any settlement strategy as a mark against their members. Fourth, land use and development. The law department helps write and defend rezonings, fights suits over environmental review, and navigates the thicket of state law. With Banks, expect more emphasis on legal strategies that unlock affordable housing, standardizing community benefit agreements, tightening timelines on challenges, and negotiating clear enforceable commitments. Also expect a harder look at developers who stall on promises. If the city starts taking more of those cases to court, deals will change on the front end. Now, the politics. The plausible villain in this story isn't a single antagonist. It's a factional council that can't decide whether it wants to govern or grandstand. There's a real policy debate here, and on that ground, good faith opposition is necessary. But when opposition reduces to slow-walking confirmations and peacocking in committee while critical roles sit vacant, residents pay the price. The backlog builds, the overtime grows, the settlements climb. Councilmember David Carr became the public face of that resistance during the confirmation process, arguing that a defender-turned-commissioner might import advocacy reflexes into a role that demands legal restraint. Others in the bloc worried that Banks will prioritize negotiated settlements and consent decrees, tying the city's hands. Some feared his tenure at social services left behind an expensive footprint without clear, measurable results. Those are concerns serious people can argue. But here's what else is true. The council is a political organism with its own ambitions. Blocking a mayor's high-profile legal appointment sends a message to donors and constituencies that you can punch above your weight. It might feel like leverage. It also risks kneecapping the legal department at a moment of maximum exposure. Riker's oversight, asylum litigation, a wave of tort claims from infrastructure failures, and a stack of appeals in education and disability rights. Let's talk dominoes. Domino 1, legal policy. With banks confirmed, internal guidance to agencies will shift. Expect tighter memos on when to declare emergencies and how long they can last before oversight kicks in. Expect stronger review on surveillance technologies used by public safety agencies, what can be deployed, with what warrants, and how long data can be stored. Expect more rigorous pre-litigation negotiation in housing and social service disputes. That means fewer chaotic 11th-hour courtroom brawls, more formal frameworks. Domino 2. Staffing. A credible plan to stop attrition is step 1. That likely means a targeted pay bump for trial attorneys, a structured mentorship track to grow appellate talent, and a hybrid schedule to compete with private sector flexibility. If he can cut outside counsel by even 10% through retention, the savings could cover those bumps. If he can't, the outflow continues, and so does the spending. In plain terms, either the city rebuilds its in-house muscle or it keeps renting it at a premium. Domino 3, settlements versus trials. Look for a recalibrated settlement grid, data-driven ranges pegged to case categories and plaintiff profiles, with authority delegated down so decisions don't stall on the 5th floor. That speeds resolutions and reduces legal fees. It can also anger claimants looking for headlines and frustrate defense-minded insiders who think fighting on principle saves reputational capital. The right balance is pragmatic. Settle cheap early when you're likely to lose, fight smarter when precedent matters. Domino 4. Affirmative litigation. Banks knows how to use the courts as a public interest tool. The city can go on offense against corporate practices that drain household budgets, predatory lending disguised as service fees, deed theft rings that strip equity from elderly homeowners, wage theft schemes targeting undocumented workers who fear retaliation. If the law department invests in that unit, the returns can be more than symbolic. Cash back to victims, penalties that deter, and a reputation that chills bad actors from even trying it here. Domino 5. Budget. The law department's work translates directly into lines on the city's expense sheet. Win early, pay less. Lose late, pay more. That's the math. But the invisible budget line is opportunity cost. Ethically and efficiently clearing claims and settling standards frees other agencies to move. That's fewer projects stuck because of legal cloud cover, fewer pilots shelved because counsel is overloaded. More predictability for nonprofits contracted by the city to deliver services including shelter and healthcare. Predictability is not a headline. It is how things get built. What does this mean for residents? If you're a tenant in housing court, watch for whether the Right to Counsel program sees renewed support from the city's legal brain trust. The law department doesn't run it, but its posture shapes funding decisions and court coordination. If you're in a shelter, the department's stance in court will help decide how long you can stay, under what conditions, and what recourse you have if the system fails. If you're a victim of a city worker's negligence, a faster and fairer claims process means you don't have to spend a year reliving trauma to see a resolution. If you're a small business owner tangled in agency contradictions, a stronger internal counsel function could clear the way faster and spare you from hiring your own lawyer just to get a permit. The stakes are personal, even when they sound bureaucratic. Let's come back to the confirmation itself. The council did its job, vetting, pushing, and ultimately deciding. The mayor staked political capital on a choice that aligns with his broader posture: more rights enforcement, more negotiated standards, more proactive courtroom strategy. The opposition saw risk in putting an activist-turned-bureaucrat in the driver's seat of the city's legal apparatus. That argument will not end tonight. It will replay case by case, memorandum by memorandum. The early tests are already on the docket. The asylum seeker shelter policy, where the city must defend the contours of right to shelter amid unprecedented intake. Federal oversight at Rikers, where compliance deadlines and staffing shortfalls collide with legal mandates. Police protest litigation, where the city must balance protecting constitutional rights and defending officers from blanket condemnation. Education suits on services for students with disabilities, where the backlog of impartial hearings ballooned during the pandemic and families wait too long for relief. Land use fights that set the pace of housing production when the city's vacancy rate is at a generational low. None of these cases starts with a clean slate. Precedent and politics stack the deck. What changes now is who plays the hand. Critics of banks inside the council have warned that his instinct will be to settle and codify. To them, that feels like surrender, but there's a different way to see it. Consent decrees and detailed settlements are governance tools when used carefully. They can bring daylight to dark corners of government, set real timelines, and stop the game of endless extensions. Used recklessly, they can handcuff administrators and lock in unrealistic promises. Used wisely, they create discipline where improvisation has failed. That's the balance to watch. The other balance is cultural. Every law department sets an internal tone. Some pride themselves on being the adults in the room, the ones who tell agencies, "You can't do that." Others are fixers, finding the narrow path to, "Yes, if you do it this way." Banks's reputation is that of a yes-if lawyer with an advocate's heart. The council just handed him the keys to the machine that must decide which ifs the city can live with. For the political class, the immediate incentives are clear. If a big payout hits the headlines, critics will say the new council pays too easily. If a tough case goes to trial and the city loses badly, they'll say he fought a loser. That dynamic never ends. The longer story is in the trend lines: claim volumes, average resolution times, staff retention, the share of work kept in-house, the number of consent decrees with measurable compliance, the balance between defense and affirmative cases. For the rest of us, the question is subtler. Does city government feel more predictable and more just? Are the rules clearer? Are vulnerable people safer? Are bad actors warier? Does the city stop bleeding money on avoidable mistakes? Do agencies stop hiding behind council and start collaborating with it? Lawyers can't fix everything, but they can make everything run either a little smoother or a lot rougher. Tonight's confirmation will either mark the beginning of a coherent legal strategy for a city under strain, or it will become another rotation in a carousel of churn. The mayor owns the bet, the council holds the receipts, and Stephen Banks walks in tomorrow to face a calendar, not a campaign. Here's what I'll be watching in the first 100 days. Does he announce a recruitment surge with concrete numbers? How many trial attorneys? How many appellate specialists? What timelines? What pay adjustments? Does he name a deputy for affirmative litigation with a mandate to go after frauds that prey on the poor and the elderly? Do we see a public dashboard on tort claims, volumes, median times to resolution, settlement ranges, so taxpayers can see whether efficiency is improving? Does he move on internal culture, setting clearer authority thresholds so frontline lawyers aren't waiting weeks for approvals? Does he publish revised guidance on emergencies, surveillance, and settlement authority, signaling a shift towards standardized, transparent practice? And does he show that he can say no to agencies cutting corners, to advocates pushing for standards the city can't meet, to political allies asking for exceptions that will unravel in court? Saying no, judiciously and in public, is how a legal department earns trust across factions. If the political opposition in the council is serious, they'll pivot now from performative skepticism to meaningful oversight. They'll ask for metrics, not headlines. They'll hold hearings on outcomes, not theater. If they keep playing for noise, we'll all hear it, and we'll all pay for it. The law department is not glamorous. It does not ribbon cut. It rarely gets applause. But it is the organ that sets the rhythm of governance. Tonight, that rhythm changed. Whether it sharpens or stumbles will determine the tempo of everything else. I'm Laura Hansen. This is not the end of the story. It's the start of a ledger, measured in cases won and lost, in promises kept and broken, in people helped or left behind. We'll keep watching. We'll keep the receipts. And we'll be here when the next domino falls.